Let our meeting resume. All right, Brian, we were getting ready to dive into the G300 study.
Yeah,
Do you want to
agenda
go ahead?
item 4. Yeah, this has 2 memos. This is the general topic for both is the same, which is state and local access to information from communication service providers. That was a topic we were studied back in about 5 years ago. And because of superseding legislation, Calekba, we put a pin in our study with the intent to come back later and work through the different issues we'd identified. And that's what we've been doing for the last few meetings. And these 2 memos present the last 2 items that the commission had identified as possible study topics. And they present sort of broad questions in that they're both in the same posture of asking the commission, do you think that this is enough of a problem in practice, what the topic discussed in the memo? Is it enough of a problem that it would be justified for the commission to study it further? Because with some of these topics, we identified them, and they make logical sense, but we don't have practice experience in this area, so we don't know whether they are actual problems in the real world in practice. And so that's a big question that we've been asking throughout this series of memos, is we're asking law enforcement and civil liberties groups to give us a reality check. And each memo discusses a different topic, but has sort of the same general posture. So I'll start with the first one. Which is Memo 2020-54, and it involves an existing penal code procedure that's part of the Wiretap statute that's used to minimize the interception of privileged communications. As the memo explains, there's also a general rule in the Wiretap statute on minimization generally. So that applies to communications that aren't pertinent to the purpose of the search, or anything else that's beyond the authorized scope of interception. And I assume that would include privileged communications. So the general landscape is that there's a broad minimization requirement, and then it's supplemented with a specific narrower minimization requirement that applies if you hear that the communication is or appears to be privileged. So you've got a wiretap up, you're listening to your suspect starts a phone call, and it's obvious they're talking to their attorney or their doctor or somebody who is potentially in a privileged relationship. Existing Penal Code Section 62980 imposes this very specific procedure that you have to follow if you're law enforcement, where you turn the tap off for 2 minutes. So you're not capturing that content at all. And then you can turn it back on for 30 seconds to sort of sample the communication to see if it still appears to be privileged. If it is still privileged, then you turn it off again for another 2 minutes and then turn it back on for 30 seconds, etc. And you can keep turning it off and back on until the communications aren't privileged anymore. So that's a special rule that applies to wiretaps. That statute, by its terms, applies to electronic communications, which includes not just the kind of streaming communication that was the original subject of the Wiretap Act, like a live telephone conversation or a listening device. Or now this meeting that we're having is streaming. It also applies to what in the memo I've called asynchronous electronic communications. So like email, text messages, things where there's a communication going on, but it consists of a series of discrete messages sent at different times in sort of a series. And so there's not a continuous stream. There's a collection of moments. And as I point out, and I don't think anyone has disputed this yet, the existing requirement of 62980, this 2 minutes off, 30 seconds on sampling process, doesn't make any sense when you're applying it to asynchronous communications. Doesn't have any obvious, practical, workable application. I did see a case where the defendant had argued that that the way you would effectuate something similar to that would be to read an email with a ruler where you read line by line. And if you hit a line that has privileged content in it, then you have to like skip 30 lines down and continue reading or something like that. So yeah, there might be ways to creatively replicate something similar, but to me that's just finicky, and it would be hard to effectuate. So what the memo is about is whether or not there is some way to approximate the desired end result of 62980, which is to minimize the interception of communications that appear to be privileged when you're intercepting asynchronous electronic communications. Is there some way that you could get close to the result that you get under the existing statute? And the suggestion that's made in the memo is that you might be able to use the metadata for the asynchronous communications. And as the memo explains, metadata is basically anything other than the content of the message. It's the wrapper around the message. So who sent it, who received it, when was it sent, how was it routed through the internet, etc. All that kind of stuff that we ignore most of the time. You could conceivably use that to identify communications that have some indicia of being privileged. So for example, if you knew the email address of your suspect's attorney and you saw that your suspect sent an email to their attorney, there's reason to believe that might be privileged, you know, beyond the normal email they're sending to other people who aren't in a protected relationship with them. And so what I've suggested is that it might be possible to develop a rule that has two basic components to it. One is a trigger, and the other is special treatment. And as I suggested, the trigger for special treatment should probably be simple and bright line. If it requires a subjective assessment, it's going to get really difficult for law enforcement to know which messages require special treatment, and there's going to be line drawing problems. There's going to be litigation about it after the fact, challenging their determination and trying to seek to exclude the evidence, etc. So I think it might be workable to have a rule that simply says, if a communication is sent between two people who are in a protected relationship that's subject to an evidentiary privilege, then that message needs to receive special treatment. So between a person and their attorney, person and their doctor, psychotherapist, member of clergy, if you know that, I mean, if somebody's email is Memo 1128, you wouldn't necessarily know that was the attorney. But if you in fact knew that that was the attorney, then maybe that warrants special treatment. I see a question from Commissioner Carrillo.
Yeah, I was actually waiting for you to get to that point. I was fairly interested in the possibility of applying the special master procedure to this issue. I see that you covered it in the supplement in responding to a stakeholder comment. So if we wind up studying this, that's an interesting idea. It's something we could potentially consider. And I agree with you, the fact that there is a special master proceeding the legislature has provided in other similar contexts arguably encourages us to at least study the possibility of potentially applying that in this circumstance because of that similarity.
Right. So once you have a trigger that requires special treatment, then what do you do for the special treatment? And as Commissioner Carrillo points out, one of the suggestions is a special master. It would be a subordinate judicial officer who would be a neutral, and they would review those communications that meet the triggering condition, not all communications that are intercepted, but just those with some indicia of likely privilege. And they'd look at them and screen them. If they find they're not privileged, they could turn them back to the law enforcement. If they find they are privileged, they seal them and give them to the judge who authorized the search. And as Commissioner Carrillo points out in the memo, I note that, you know, there's existing precedent for this kind of thing. Calekba itself has general authorization for a court to appoint a special master. It doesn't say to do what. It doesn't specify what their responsibilities would be, but it creates statutory authority. There is case law that says courts have inherent authority to appoint subordinate judicial officers like special masters to screen evidence for privilege. And there is an existing procedure that's not in the wiretap context, but it's in the context of a regular search warrant, where if you serve a search warrant for documents in the offices, I believe it is, of an attorney, doctor, psychotherapist, member of clergy, you have to have a special master who goes in and conducts the search. And if items are identified as privileged, they're claimed to be privileged, then those items are sealed and given to the court rather than handed over to investigators. So there's precedent for it. Another possibility that I raised was what I nicknamed an embargo approach, where you don't involve a special master. Law enforcement finds the trigger's been met. You know, here's an email between the suspect and their attorney. They just seal it and give it to the court. And so it'd be like a sort of more mechanical, blunt approach. And as I point out, and the commenter in the supplement is Assistant Head Deputy District Attorney Burnley from the Los Angeles District Attorney's Office. That's not just a blunt approach, but it would probably be problematically blunt in some situations, because it would exclude evidence simply on the fact that on its face, it's a communication between two people that might be privileged. But as the memo explains, not every communication between two people that are in a protected relationship is necessarily privileged. And the example that's given in the memo, and that AHD Burnley notes in his letter on the supplement, is the crime fraud exception to the attorney-client privilege. You do not have a privilege if the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit a crime or fraud. So, you know, it may be that if somebody reviewed a communication between a suspect and the attorney is a participant in a crime, and this communication is to facilitate that crime, that would not be privileged. And so a special master might be in a position to make that call and hand it back to law enforcement. A simple embargo rule would not allow that kind of nuance. And let me note, the footnote in my memo is incorrect. When discussing the crime fraud exception, I have the wrong code section. Sorry about that. It's in the evidence code 956A. So those are two possibilities: the special master, the embargo at the law enforcement level. I do posit the possibility that if we did the embargo approach, you could also create a right to sort of an expedited judicial determination of whether communications are privileged. So law enforcement might have to seal it, but they could ask a court to take a look at it and screen it for privilege. That's a possibility. I don't know what that kind of I don't know enough about this area of law to know what that would look like. Commissioner Carrillo?
Yeah, Brian, sorry for jumping in again, but there is another somewhat analogous proceeding that if the commission decides to review this, it could consider as one of the possible options as an alternative to a special master. And that's a pitches motion procedure where law enforcement will bring a box full of documents of potentially relevant impeachment material, bringing it to a judge and having the judge sort out what is and is not disclosable. So it basically would be a reverse of that procedure where you have to bring in, like the embargoed materials or whatever, and the judge gives some of them back to you. But I mean, my point is there are examples from existing law that we can draw from if we're going to recommend a procedure. And again, to me, the fact that there are such procedures for dealing with privilege matters, it seems to me to at least argue that we should at least look at this.
Right.
Brian, what is this study not better suited for the Criminal Commission or CLRC?
In theory, we're not barred from looking at things that happen to be in the penal code. And this is actually the result of a study we were specifically assigned years ago. And I think that the committee right now is focusing more on sentencing and alternatives to incarceration and not so much on criminal procedural matters like the conduct. I think it would be a few years before they would have a slack in their schedule to look at something like that. Whereas this is something we have already identified as an issue.
Is there a way that we should even present it or have them be aware that it's on our agenda and then they decline to add or provide any resources to our further study?
I could mention it to the chair just to let him know and see if he has any concern about it.
I think for me, I think it's like just as a matter of just to make sure that we're working hand in hand with them.
Okay.
Commissioner Simpson, you have.
Yeah, maybe for Brian. I kind of agree with David. This sounds like an interesting thing to take a look at. But I think if I understand correctly, we've been talking about if the metadata triggers a concern and having a process with an embargo or a master summary to find out whether or not it's a false positive, I'm also curious about the inverse of that. If there's privileged communication that hasn't been triggered by the metadata, we don't know the lawyers use the personal email address or something with a doctor or a clergy or something like that. How do you deal with that?
Yeah, I think that my understanding of it is general, but my sense is, and we actually have somebody on here who's in the LADA's office. We'll give a chance for comment later, but he may be able to answer better than I do. My sense is that, in any kind of search, if your search sweeps in privileged content, there's a process for dealing with it. I think at a minimum, that the defendant could object to its introduction as evidence at trial because it is privileged and privileged material can't be admitted as evidence. This is a question, I think, of going one step beyond that, which is not allowing law enforcement to even see it.
Right. To not collect in the first place.
Right.
Okay.
Right. And, so that's what the existing procedure does. It makes you turn off your wiretap so you can't even hear it. But when we get to the point of comment from members of the audience, it might be worth raising that question again. Like I said, a big question I ask in the memo is sort of how does this work in practice? Because this is not an area that I have any practical experience with. But I will say there was one more possible approach suggested, which was from AHD Burnley, which is if an email meets the triggering condition, then an internal monitor reviews it to determine whether it's privileged. So this is not referring it out to a special master, not embargoing it, but instead having somebody who's assigned the function with either within the police department or presumably within their associated district attorney's office, who would be firewalled off from the investigators and who would perform the function of taking in these triggering communications, looking at them and saying, oh yeah, these ones clearly are privileged, I'm going to seal those. These ones are not. So like essentially the same thing as a special master, but doing it in-house with somebody who has an ethical firewall where they're not allowed to communicate anything they learn to the investigators. I think the reason that came up is because in discussing all of these possibilities, well, there's two things that came up. One was cost and delay, right? That was a concern that Mr. Burnley raised, was that if you refer things out to a special master, somebody's going to have to pay that person. They're an attorney appointed by the court, presumably, and it's going to slow things down. And in a wiretap situation, maybe there's special urgency where it would impede the investigation to have to wait for a special master to be appointed and make determinations about what's privileged and what's not. It would be much less expensive and burdensome and slow if you could use an internal person who's designated for that function to do the same thing, and maybe sufficiently protected. Now, the other thing that came up in response to AHD Burnley's letter is that I had asked in the main memo, how does this work right now, right? Like if you're using an interception order, a wiretap order, and you're collecting somebody's email or their text messages, obviously you can't do this 62980, 2 minutes on, 30 seconds off thing. So what do you do? And the letter from Mr. Burnley suggested to me that possibly what you do is you just fall back into the general minimization requirement. Because you recall, the Wiretap Act has a general minimization requirement, as well as, so that's in Penal Code 62958. Every order and extension thereof shall contain a provision that the authorization to intercept shall be executed as soon as possible, shall be conducted so as to minimize the interception of communications not otherwise subject to interception under this chapter. So you're getting a court order authorizing the wiretap. The court can put conditions into it to require you to minimize the interception of material that you should not be intercepting. Now, it may be that when you're using an order like that, a wiretap order to intercept email or text messages, maybe in practice, the courts are already putting in place restrictions that are sufficiently protective. That's a possible answer to the question I asked about, like, how is this being handled now? And so one of the issues that I thought was worth thinking about, and I'm almost done talking, so we can also hear from our witness, is whether or not this is actually a problem in practice, or whether or not the courts and law enforcement are making it work somehow under the existing general minimization rule. Now, I will say that we got a letter from Chris Conley at ACLU, Northern California. I emailed it out to commissioners right before the meeting because we just recently got it. We will attach it to a memo shortly after the meeting, so it goes into the public record and everybody has access to it. But the short answer is ACLU suggests that we work on this, and they suggest that we investigate the special master approach. I suspect that they prefer the special master because it's probably the most protective of the privilege. It is a process that requires a third party who's a neutral to make the calls. They also point out, and this is something we've heard from them repeatedly, they do not like it when we talk about the possibility of creating special rules that are in tension with the general California Electronic Communications Privacy Act, Calekba, which they sponsored and championed 5 or 6 years ago successfully. And so I think part of what appeals to them about the special master possibility is the fact that Calekba already includes authority for courts to appoint special masters. So I think they feel like specifically requiring a special master in this situation would be harmonious with the existing rule in Calekba. So that's all I have to say, sort of to set the table. I will say we do have Mr. Burnley in the audience, and if he's willing, I think it would be helpful to hear his perspective on this, because he's skeptical of the need for any special reform here, and he's also an advocate for a light touch, something that's not going to overburden law enforcement. Mr. Burnley, if you're interested in speaking, why don't you click your hand raised button? He does indeed wish to speak. May I recognize him, Chair?
Yes, please. And then also too, I was just wondering, do we have anyone from the ACLU? Is Michael?
No, he wasn't going to be able to make the meeting.
Okay.
Okay.
Mr. Burnley?
You should now be permitted to talk, but your microphone is showing as muted. There you go.
Okay, so good morning, everybody.
Good morning.
Just a couple of items I'd like to address at the outset. First of all, it's interesting to note that 629.80, it does not define what a privileged communication is. It just says privileged communication. It doesn't refer to any particular statutes in the evidence code, which has always struck me as a little odd, because we're sort of left to our own devices in figuring out what a privileged communication is. And typically it's attorney-client, doctor-patient, clergy-penance, and that sort of thing. I'd also like to note that Calekba, there's a specific exclusion in Calekba for the wiretap statute. So I've always viewed the wiretap statute as sort of standing on its own. It does not fall within the provisions of Calekba. It's got its own requirements for notice, inventory, et cetera, et cetera. In my experience, and I've been a deputy DA for nearly 25 years, and I've been involved in wiretaps since approximately 2008. In my experience, the interception of privileged communications is exceedingly rare. And when it happens, first of all, the monitors who are listening to the conversation in real time, they're all post-certified. They have to take a class. They're either civilian monitors, excuse me, or they're law enforcement officers who have taken the post class. And if they intercept a conversation, and we'll talk about an oral conversation, during the conversation, if they realize that it's a privileged communication, they will implement the 629.80 procedure. Now, we will find out about that privileged communication only because in Los Angeles County, our law enforcement officers are required to let us know if they've intercepted any privileged communications in the 10-day reports, which they have to submit every 10 days to let us know how the wiretap is progressing. And these conversations, the fact that we did intercept a privileged communication is flagged, and the judge is alerted. Our designated wiretap judge is alerted, who incidentally I think is in the best position to evaluate any of this, not a special master, but the actual designated wiretap judge in a particular county. Excuse me. And then once the conversation, and we know that a particular phone number belongs to a particular privilege holder, the computer software that's used to intercept these conversations is then set up so that number is flagged, and so the monitors are aware that that is a potential number of a privilege holder, and to either not intercept it at all or to make sure that they pay very special attention to that conversation. Now, with respect to an email or a text, the same procedure is essentially followed. The monitor will get that conversation over the computer software in real time. Once that monitor realizes that the communication is privileged, that communication is flagged, that communication is locked. So only a person with administrative privileges would have access to that conversation. The investigating officer, other wiretap monitors, or other law enforcement officers who are engaged in the investigation, they cannot have access to that information. And again, the fact that a privilege holder was intercepted pursuant to the wiretap We are alerted of that in our 10-day report, and we let the judge know. So we would let our designated wiretap judge know that an intercepted communication involved a privilege holder. And we also specify what procedures we're putting in place to make sure that that does not happen again. Now, in the event that it appears that the crime fraud exception may apply, we would make an appointment with the judge, and we would let our designated wiretap judge know, this is what we intercepted, this is what we believe is going on, and we would request permission to continue to intercept these conversations because we believe that the privilege holder is engaged in a crime with the target of the wiretap. And if the judge agrees with us, he will sign an order which authorizes us to do that. Now, again, as I said at the outset, this is exceedingly rare. In the past, since 2008, I can probably count on one hand the number of times that this has actually happened. Just see. And another point I would like to make is, I guess the question is, at what stage in the investigation would this become an issue? Wiretaps are only valid for 30 days. So during the investigation of the wiretap, when the wiretap is up and active, the only individuals who know what's being intercepted are the monitors in the wire room, the investigating officer, the judge via the 10-day reports, and the district attorney's office, because we're in communication with the IO and with the other individuals, and we review the 10-day reports before they're submitted to the judge. So once the wiretap goes down, if charges end up being filed that are derived from that wiretap, and there are in fact crime fraud exception communications that we would like to use, all of that would be litigated by the judge. If charges are not filed, say the wiretap is not productive, we don't get what we were looking for, the wiretap goes down, the wiretap is sealed, inventory would be then served within 90 days of the termination of the wiretap. All individuals who were intercepted would receive an inventory letter, and if a privilege holder did in fact get intercepted, either and the conversation was minimized or it was listened to, that privilege holder would receive a letter, and there's a procedure in the penal code which would allow that privilege holder to make a motion to the wiretap judge in order to get to whatever communications may or may not have been intercepted. So that's generally how we handle these sort of matters. We focus primarily on our wiretap judge because we believe that that individual is in the best position to understand the wiretap laws and is familiar with the investigation, and we have ready access to him. And we're LA County, with 10 million people, and if we need to make an appointment with our wiretap judge, we can easily do that. He's just across the street from us, and we can converse with him, make whatever motions we want to make whatever requests we want to make, and submit any whatever documents we'd like to submit to him. So that's all I really have, but I'm more than willing to answer any questions.
Commissioner Carrillo, but you're muted, so you need to unmute yourself.
Yeah, to me, the question is whether the commission should take a look at this issue, and I think we should. I give full respect to LADA for the meticulously thought out procedure that they're using. That's quite laudable. The problem I see is that LADA and the law enforcement agencies it works with, they're a very small subset of all the law enforcement agencies in the state. So however well they may have put together a procedure, that says nothing about anyone else. I also agree that these kind of privilege issues are rare. I'm a special master. I've been one for years. I think I can count on one hand the number of times I've even gotten an inquiry to have me assist in a privilege review, and it's never actually happened. I've never actually had to do one. So, on my slice, I have to agree this is fairly rare, but that doesn't mean that it's not important. And for a small law enforcement agency that doesn't have an established procedure, because it is so rare and because they're small, they'll be left on their own. And I'd rather spend a little bit of the commission's time putting together an off-the-shelf procedure in the event that someone actually needs it someday, because the privilege is important, whether it's for attorney-client or doctor-patient or priest-penitent. I'd rather not have to leave a law enforcement agency in the position of having to wing it and get it wrong, and both potentially violate the privilege, which is bad in and of itself, and then also potentially lose the case because the procedure that they come up with is inadequate for whatever reason. So I would say we should at least take a look at this. The last point I'd make is, I very much appreciate the comments from LADA. Those are very useful and helpful. It would be equally useful and helpful to hear from, as Brian pointed out, potentially the ACLU, people on the other side of this. The state bar may have some thoughts on this. So I suggest that it's something that merits at least a few minutes of the commission's time looking into it further.
I like it.
Madam Chair, I'm sorry, you can't see me, Madam Chair, because of my, I'm sorry. I just wanted to weigh in briefly on this particular issue because I have actual personal experience with it. At one point during a very high publicity trial that our office had, we discovered during discovery that was turned over to us. We are on the defense side, and we requested discovery from the district attorney, and they had tapped our conversations with our clients and recorded them and kept them. We only found that out when we requested discovery and received them. They were then not introduced into court, but sadly, during the whole time of that case, law enforcement officials had heard conversations that were privileged between us and our client. So perhaps it is rare, but the fact of the matter is that when it happens, it is particularly egregious and it has substantial consequence. So I think for the purposes of having a transparent policy that assists both the prosecution and the defense, that we should definitely look at this issue. We should examine policies that can be uniform and prevent the type of judicial error that could happen. I know that sounds like, I agree. The LA prosecutor, I appreciate all your comments, and I think you sound like you're being extremely meticulous in how you approach this issue. That's phenomenal. But we have hundreds, if not thousands, of enforcement agencies across the state that probably don't have the resources that you do, and also don't have the guidance that could be instrumental in making sure that these issues don't happen. So that is my perspective on this, and I would like the commission to address it.
Thank you. Are there any other, Brian, I wanted to just add a comment too before we move forward. So what were you going to say though? I'm sorry.
Oh, I was going to say, I too was struck by how the description, Deputy District Attorney Burnley's description of the LADA practice made me think it sounded pretty good. It sounded pretty well devised to protect privileges without imposing too much of a burden. It included, the quasi-neutral, I guess, of the monitor, who then locks down messages that appear to be privileged so that investigators can't see them. And then if the law enforcement thinks that there's reason to pry those open, they take it to the wiretap judge and get a determination. I would be interested in the possibility of looking to the LADA's practice as a potential model, and would be interested in getting something in writing, if possible, that describes it from LADA. I'm not saying that that is where we'll land, but at least it's worth having it out as a possible approach if the commission decides to pursue this further.
Yeah, it makes sense, like you said too. And LA is one of the most populous counties in our state. So I think it's, not only my home, but it also works well to kind of identify, especially because the LAPD or the LA DA's office has done so much in this area when it's not a common area. But I would say just for people who don't practice in the criminal law arena, that I worked for a company that took tapes or recorded communications with employees. And when those tapes, it was an old situation, one of the tapes was subpoenaed, and we relied on the model that's within the penal code and looked to that procedure, and it was minuscule, but it was helpful to have something. So there is some crossover in the civil arena too, so that it makes a lot of sense for this topic to sit with our commission, with our branch of the commission, even though we do have a criminal branch. But I just do think that we just need to, Brian, like you said, just mention it to that chair, just as a matter of invitation, and I don't know, just to,
I'm happy to do that.
yeah. But other than that, it sounds like there's enough interest that we should just continue to study this topic.
Is there any commissioner who sees that differently, who thinks we should drop it? No? Anybody who wants to abstain on that decision? No? Okay.
You got
Good. So we will bring this back, and I don't need a vote on this, but my inclination would be to, in the subsequent memo, to offer at least as one alternative a procedure similar to what Mr. Burnley outlined for us. And Mr. Burnley, I'll be back in touch to ask you for your help with that, if that's okay.
That's perfectly fine. Thank you so much.
Good.
Thanks for joining us.
All right,
you.
so I think that wraps up that one. I think that's in a good enough posture that we can keep it moving forward.
Awesome.
Anything else on that specific topic, anyone? Okay, so with your permission, I'll move on to the next memo.
Please.
This one is 2020-55. Yeah. And this has to do with the use of administrative subpoenas to obtain customer information from a communication service provider. For those of you who were not with us, oh, Mr. Burnley, I'm gonna turn you off here. Hold on just a second. Okay. You know, one of the central legal pillars in this study is the Fourth Amendment to the U.S. Constitution and Section 13 of Article 10 of the California Constitution, which are similar but not identical in their effect. They have to do with protecting privacy from government searches. And so when we were doing this study earlier, a lot of attention was paid to sort of finding the contours and boundaries of that constitutional right and what it is that it requires when government is trying to access customer records, communications from an electronic communications service provider. And one of the things that we learned was that existing law, both the federal statute, California law, statutory law, case law, permits the use of an administrative subpoena to obtain private records. And as revisited in this memo, it's worth noting why the use of an administrative subpoena is constitutionally satisfactory, even though it's not a warrant based on probable cause. And in the Commission's earlier report, which I block quote at length here, there is an explanation of the case law discussing this that basically, to simplify it greatly, says you need probable cause for a warrant because a warrant has immediate intrusive effect. You know, with a search warrant, the police can like barge into your home or your business and start looking at stuff. And so the way you protect privacy is by having advance approval of a court based on probable cause. So that's the protection is front loaded because you're not going to have an opportunity to protect yourself once the ball gets rolling. An administrative subpoena is different. It's served on you. You don't have to immediately turn over the requested records. You can move to have the subpoena quashed or limited in court. So you're going to have an opportunity for an adversarial judicial process that's going to assess the constitutionality, the reasonableness, and the definiteness of the subpoena's request. And that is sufficient to protect your constitutional privacy rights. So, as explained in the memo, that protection is self-executing if the subpoena is served on the person whose privacy interest is at stake. If I get a subpoena to turn over my email, then I know I need to take steps to protect myself. If AT&T gets a subpoena asking for my email, I don't necessarily know that I need to protect myself. And it's not clear that AT&T is a sufficient proxy to protect my personal privacy interest. That is the crux of the discussion in this memo. The justification for the constitutionality of a use of a subpoena to do a search for your records turns on your ability to resist in court the effect of the subpoena. If you don't know it's happening, do you have that right to resist sufficient to justify constitutionally that search? I have doubts about that. The commission raised doubts about that in its original report. And so the solution would be to require that the customer whose records are being sought by an administrative subpoena served on a service provider, that customer be given notice. When we talked about this 5 years ago, I had some informal back and forth with a state attorney who practices in this area. And they said, yeah, in practice that usually the service provider would tell their customer. Unless they're prohibited by court order from doing so, that's the safer course for them, because then they don't have any exposure for a customer's claim that their constitutional privacy right has been violated. Typically, there are service agreements in place that protect the privacy of the customer's information held by the service provider, etc. So in practice, it's probably typically self-curing is the argument that was made. In the memo, I ask whether that's sufficient, whether we can rely on the self-interest of the service provider to protect the customer's rights. And I point out that there's a precedent in California law. There's a couple of them, but that I mentioned in the memo. I think the most directly on point is the California Right to Financial Privacy Act. This is a statute that protects customer records in financial institutions from government searches. And there is a provision in there, in that act, that expressly allows the government to obtain customer financial records by administrative subpoena, but it requires contemporaneous notice to the customer. And that is the reform that I'm contemplating here, is that for administrative subpoenas, generally, when they obtain communications from a service provider, from a third party, require them to give contemporaneous notice to the customer whose records are being obtained. So I think there's precedent for that in California. The other precedent I point to is a little less direct because it's a litigation subpoena. It's a discovery subpoena rather than an investigative subpoena. But there is a statute in California that generally protects consumer privacy when you're using a subpoena to obtain consumer records from specified kinds of business entities, which includes specifically telephone companies. So if you're trying to get customer records from a telephone company with in discovery, litigation discovery, you have to give notice to the customer. So I think there's precedent for it. The only issue that I had was I'm not sure that it's a real problem in practice, because as this attorney suggested to me some years ago, perhaps it just isn't a problem in practice because the service provider's self-interest is sufficient to keep them giving notice themselves to the affected customer. Now, we did get the letter from ACLU, and they also urged the commission to continue working on this. They think it's a problem that should be addressed. Does
Brian, I
anyone
think
have
we also
questions
had,
about my... Go ahead.
do you recall, I think we had someone from AT&T, we had a carrier come visit us as a stakeholder in the meeting too. I don't recall, but I think if we continue to work on it, we could look at what happened in the past. It's probably, and it sounds like if we already had it, if we're expressing an interest in 54, I think 55 goes hand in hand. Memo 55 goes in here. So I'm in favor of us continuing this study.
With the idea being that we'd be moving towards a proposal that requires government agencies, when they use an administrative subpoena to obtain customer records from their communication service provider, would require the government agency to give contemporaneous notice to the customer whose records are being sought, so that they have an opportunity to move to quash.
Commissioner Carrillo?
Thank you. It occurs to me that the various service providers at some point could decide that their interests lie in other directions. They could reevaluate their assessment of this. And then the customers, obviously would be at the mercy of that. I'd much rather enshrine it in the law.
That's true. I think there were some new cases too. I just recall hearing stuff on NPR about this, the carriers but I do think we should continue this study. I think that's the question on the table. Am I correct?
Yes.
Right.
Yeah, if that's the case, I'm in favor of continuing to study it.
I think so too. I'm looking at the commissioners on my panels. Are we in agreement? Okay, so everyone's giving it, and then let's see, Jane, are you there? Do you want to you're good?
I'm here.
Okay, good.
Sorry.
Okay. All right, then we're all those in favor, say aye. It looks like we're all saying aye. So Brian, you have a consensus.
Okay, thank you. That's what I needed for that memo. We'll bring it back.
It looks like Linda Brown has been waiting patiently, and I don't know if you have anything to add, Linda, or Miss Brown, but I just see you on here. Do we want to stay in order? I think Christmas probably won't take that much.
Barbara's actually.
Oh, Barbara.
The next one, yeah.
Barbara, do you want to go forward?
Okay, I'm ready.
Okay.
So this is another trial court restructuring memo on Government Code Section 70219. That's a code section that stems from the Commission's work on trial court unification. When the Commission was figuring out how to revise the codes to make unification of the municipal and superior courts possible on a county by county basis. It noticed various other problems in the codes that needed attention. And it compiled a list of those problems and indicated which organization might be suitable to study the problems, the Judicial Council or the Commission or both entities acting jointly. The legislature later enacted Government Code Section 70219, which directs the Judicial Council and the Commission to undertake the studies that the Commission identified and to split responsibility for them the same way that the Commission recommended. Since then, it's been quite a number of years. The Commission and the Judicial Council have conducted all of the studies that were assigned by Government Code Section 70219. And so the Commission prepared and circulated a tentative recommendation proposing to repeal that section, which explains that all of the studies are done and the section is no longer necessary. The deadline for the comments on the tentative recommendation has come and gone. Nobody has submitted any comments. That tends to confirm that the proposal to repeal the section is uncontroversial. And so today's memo presents a draft of a final recommendation, which is essentially the same as the tentative recommendation. I'd like to suggest one tiny change to that draft. Specifically, I suggest adding an extra citation to footnote 14. There's another staff memorandum I'd like to cite. That's memorandum 20-40, because that memorandum explains that the enactment of legislation on expedited jury trials is something that sort of followed from the joint study that the Commission and the Judicial Council conducted on jurisdictional limits pursuant to Government Code Section 70219. So is that revision acceptable to the Commission?
Yes.
Anybody have any concerns? Okay, and then with that revision, is the draft that's attached to memorandum 20-46, is that draft acceptable to the Commission as a final recommendation for publication and submission to the legislature?
I'll move approval.
I'll second it. And Barbara, and then we also offered more time for comments because of the pandemic, I think, initially on this one. So
There's been a long time for comments, yes.
yeah. No, I think that's good. Looks like, since we have a motion, all those in favor of approving the attached memo as is, or with the
revision that I just discussed.
20, okay. Everyone is, it looks like everyone's, and then Jane, if you don't, oh, you unmuted yourself, so you're
Yes,
good?
I approve.
Okay, so it looks like there are no abstentions, and I think that completes that item.
Very good.
Yeah.
All right, then we're ready for stock co-ops memo. Number 6. Brian? Oh, you're muted, Brian.
You're muted.
Darn, I said things perfectly.
Right.
This is a continuation of our work. This is Memo 2020-56. It's a continuation of our work to find a practical mechanism for transfer on death of an interest in a stock cooperative outside of probate. Before I get into the nuts and bolts, I'd like to reiterate one sort of foundation to this study, which is that it was derived from the work we did on revocable transfer on death deeds. And the reason that it's a separate study, rather than having been governed by the transfer on death deed statute, is because there is this peculiarity of stock co-ops, which is that the separate interest holder, the person who owns a separate interest, holds a stock certificate rather than a deed. And that the Commission concluded that could raise some peculiarities procedurally that would make it problematic for them to be treated in the same way as other forms of real property under the revocable transfer on death deeds statute. And it really was limited to concerns about the sort of form of ownership. So the reason I emphasize that is because I think that the work that we did on revocable transfer on death deeds generally has a lot of relevance, and we should look to it as instructive with respect to the issues as we're moving through them. And specifically, I'd say, I think we ought to presume that the stock co-op statute should essentially mirror the revocable transfer on death deed statute, except where there are reasons not to do so that depend on sort of the peculiarity of stock co-ops. And you'll see why I'm making that point in just a second. This memorandum looks at execution and revocation formalities. How do you set up one of these transfers on death? How do you revoke one that you previously set up? And it first talks about a broad question of whether or not the law should give a lot of flexibility to people to draft their own instruments for creating one of these transfer on death arrangements, or whether we should be strict and stingy in our approach to user flexibility. the statute we've been looking at as a potential partial model, the Uniform Act on Transfer on Death of Securities, is a broad and flexible statute. It's what I call an enabling statute. It says you can do it. It doesn't tell you how. And, you know, there's some rules in there about effectuation of the transfer, but in terms of how you execute one, how you revoke one, that's left up to the individual registering entities, the stockbrokers. They get to make the rules for how you effect these things, how you create them or repeal them. And by contrast, the statute on revocable transfer on death deeds is not at all flexible. Originally, the commission's recommendation was that it be flexible. We would have allowed people to draft their own revocable transfer on death deeds and allow them to do anything they wanted that is lawful. So you could do all kinds of complicated real property transfer conditions as long as they're legal. The legislature said no, and you know, very emphatically. They did not want people to have that degree of control and be able to draft their own instruments and put all kinds of complicated contingencies in, because one of their biggest concerns about revocable transfer on death deeds is that people would mess them up. That you're talking about an instrument that's designed to be used without the advice of counsel, by lay people probably in many cases. And if you had lay people drafting their own instruments and trying to get clever, the concern was that the risk would be too high that they would make a mistake, or that it would be unclear what they intended, and you'd have to have litigation to like interpret the instrument. And so the legislature insisted, as a condition of moving forward with enactment of the statute, that very severe guardrails be put in place. And so as enacted, the RTO-DD statute requires the use of a mandatory statutory form. You don't get to draft your own instrument. And that form is limited to the simplest kind of conveyance, equal division between named beneficiaries with no lineal descent. So if one of your named beneficiaries dies before you do, that gift to them fails. It does not go on to their children. So if I say to my 3 children in equal shares and one of them dies before me, it winds up to my 2 surviving children in equal shares. The children of the deceased, the grandchildren of my deceased child are out of luck. That may not be the best approach. It might be, it's tempting to give people more control than that, but the legislature said no, they wanted everything to be locked down. So we have the same question here. If we create a statute that allows the transfer of stock co-ops outside of probate using instruments that are executed by people without the advice of counsel, without the assistance of counsel, do we allow them to draft their own instruments? Do we allow for flexibility as to the terms of the transfer? Or do we mimic what the legislature did with the revocable transfer on death deed? I think this is one of those instances where the fact that stock co-ops are peculiar doesn't really bear. It's not really relevant in answering this question. I don't see why the legislature would have a different opinion on this issue about stock co-ops than they had about any other kind of real property. And so I think that we could do whatever we wanted, but I kind of think that whatever we do, it will be squeezed down into the same thing that the RTO-D deeds was squeezed down into. And there's some advantage to just adopting a uniform and consistent approach from the get-go. Just do what the existing law already does for other kinds of real property. So that's the first question for you to decide. Flexible or inflexible?
Who's unmuting themselves?
Well, in the absence of discussion, my recommendation is that we do what the legislature already did. And I see a thumb from Commissioner Simpson.
Yeah,
and Ruben.
I think we're good.
I would agree. I would agree.
Okay, so I'm not hearing any disagreement. I see lots of affirmation. And okay, so moving on, and this one's even easier because there really isn't a counterpoint to it. The question of form of revocation. The revocable transfer on death deed statute provides two ways to revoke. One is by the use of an express form, statutory form. So you print the form out, you sign it, you do whatever you're required to do. The other is by the creation and execution of a new instrument. So if you have already an RTOD deed and you execute a second one, the second one revokes the first one. So it's either an express revocation by form or an implied revocation by the enactment of a superseding instrument. I think that covers all the ground satisfactorily. I don't see any reason for this statute to differ on these issues from the RTOD deed statute. So my recommendation is that we just follow the same model that we are already using for RTOD deeds. I see a thumb from Commissioner Simpson. Yeah.
There are no comments from the attendees? No one wanted to raise a hand?
I don't think we have anybody here from the bar.
Okay.
Okay, so I didn't see any dissent on that point either. The last one that I think is ready for decision has to do with capacity, decision-making capacity. The existing law provides for different standards of decision-making capacity for different kinds of acts. And so when the commission was doing its work on revocable transfer on death deeds, it had to decide which standard of capacity should control. We didn't have to, but if we hadn't, we'd throw it to the courts and they would decide. So better to anticipate and answer it in the statute. So there are two competing standards. One is the standard testamentary capacity, the capacity to make a gift. That's the standard that controls wills or grant deeds. And it basically, to paraphrase, to make a will, the decedent must understand the nature of the act, the nature of the property, and the decedent's relationship to family members and others. So you know what you got, you know that you're making a gift, and you know who the people important to you are, you know, the natural objects of your bounty, right? You know your relatives and friends. That's enough to make a gift. The standard to make a contract is higher. It's stricter. And this is also for a real property conveyance other than a gift deed. To make a real property transfer, the decedent must have the capacity to contract. That requires the decedent understand the rights, duties, and responsibilities created by the act being performed, the probable consequences of the act for the decedent and other persons affected by it, and the significant risks, benefits, and reasonable alternatives to the act. So that's a stricter set of requirements than for making a gift. And you know, that makes sense when you're entering into a contract, you really understand, like, what is this going to do? How is this going to affect me, the people I'm trying to affect? What alternatives were there? What are the risks and benefits, right? So it's more of an obligation that you're entering into, and therefore you have to have a fuller understanding of it. When the commission originally made its recommendation on a revocable transfer on death deeds, it chose testamentary capacity as the statutory standard for those deeds. The logic being, this is a gift, it's a will substitute, and so we ought to use the testamentary standard that applies to a will. Again, this was one of the areas where the legislature rejected the commission's recommendation. When this got into the legislature, they said, no, we want the stricter contract standard. And, you know, they got their way. That was a condition of enactment. And I think it's consistent with their general reaction to our proposal, which was they were very worried about people being abused and making mistakes and not understanding the consequences of what they're doing. And so putting a higher capacity standard made it more likely that people would understand the consequences of their actions. Or if they didn't, there'd be a way to unwind it. You know, and so in general, they tightened all the screws down. This was one of those screws. I don't really see why they would have a different view on stock co-ops than they did with respect to any other kind of real property. So my recommendation, again, consistent with the theme in this memo, is that we stick to the approach that the legislature chose and use the contract standard.
No comments.
I would agree with that.
Yeah.
So that's one, and
I
I'm
agree.
in a second. Okay, I
All of
see
us, yeah.
positive reactions from everyone. Okay. The last issue I think is not yet ripe for decision, but I'll just briefly introduce it and then we'll be done. And this has to do with authentication. So with the revocable transfer on death deed, we required that it be notarized and recorded, right? That's the original enactment. Then we came back and did our follow-up study, and we were reacting to concerns about fraud. And we, in our follow-up recommendation, which has not yet been enacted because it got knocked out by COVID this year, we also were proposing to add a witnessing requirement. So it'd be notarized, witnessed, and recorded. There are a couple of things that are different here about stock co-ops that make me unsure about whether we should follow the same approach. One is I don't really know the extent to which there is a document that's recorded. That's part of the whole question that launched us down this separate path, because if you got a stock certificate rather than a deed, do you need to record it? Do you, when you buy one of these things, do you record it? When you sell one of these things, do you record it? When you gift it, etc. I made some inquiries about that, and I spoke to somebody who is part of a statewide co-op organization that I think is largely focused on these limited equity housing cooperatives where the purchase price is artificially capped to maintain them as affordable. And they said that, you know, when people are buying into these LEHCs, they typically don't need financing because the prices are low enough that they just come up with the cash. And so they typically don't record anything either. They just pay for the certificate and take the certificate. But they said that sometimes you do have financing involved where they're not LEHCs. And I guess, like, for example, if you know Contra Costa or the greater Bay Area, there is Rossmore, is this extremely large senior age-limited community that includes a bunch of different CIDs, including ones formed as co-ops. And it turns out there's like 3,500 co-op units in Rossmore. So I was referred to and spoke to some real estate professional who focuses on Rossmore and deals with these co-ops all the time. And he said that, you know, they're not LEHCs and the units can be pretty expensive. And sometimes they do require financing. And he said that it is common when you're dealing with a lender to require title insurance. And as a consequence of that, some kind of recordation of evidence of the transfer. I still don't have a final answer on what that looks like. I've got to follow one more step in the chain. I'm going to be talking to some escrow people who work with this realtor. So I don't yet know what the answer is going to be on recordation. I hope to have that answered before our next meeting and we can have an informed discussion of it. The other thing,
Brian,
that
can you ask them how DocuSign fits in with that? Because, like, if someone dies, you cannot get access to their Google address. You don't know what they've signed electronically, where that's gone. I'm just curious, now that we're in this new world and space, I think it would just be nice for me if, since you have access to someone, I wonder how that fits in with any of this.
So like remote execution of the escrow documents?
Yep.
Okay, I can ask them, see if they can tell me something about that. The other thing that I think is different about these instruments, stock co-ops, as opposed to other kinds of real property that could be transferred by RTOD deed, is that this system is going to require, or could depend, we haven't made this decision yet, but to some extent could depend on the participation of the registering entity, the stock co-op board itself. So this is different from if I own a single family home and I record a deed transfer on death deed. I don't have to tell anybody about that. It gets discovered later and operates. If I do one of these in a stock co-op, there is a stock co-op board that represents the corporation for the share that I hold. And if we're following the model of the transfer on death securities statute, that model depends on registration in transfer on death form with the registering entity. So it's more akin to like pay on death designation on a bank account, or a transfer on death designation on your car title with the DMV, right? You are involving a third party registering entity who is the one who keeps a record of your designation. And it seems possible to me, especially if we're talking about some of these where there's currently no recordation that goes on, it might be possible to rely on the co-op board as a registering entity as a form of authentication, right? Like, not just have I filled this thing out, but I actually took it to my board and got the secretary of the board to sign it. You know, that's a pretty good indicia of authenticity, and it's also a person who could attest to, you know, my apparent freedom of choice and mental capacity. It might be a good substitute for witnessing. So I don't yet know how all of these pieces would be arranged best, because I don't think we yet have enough information. So I'm just previewing for you. This is the piece that I'm intending to bring back next, hopefully with more information so that we can figure out how to arrange these pieces to get a good authentication approach. Anyone have any questions about that? Okay. I don't have anything else for the meeting. And we got 7 minutes left, so we're early.
All right, very good. Does anyone have anything else further to add or to say? Hang in there, everyone. All right, I think we'll go ahead and adjourn the meeting.
All right.
Bye, everyone. Thank
you
you
all. See you in November.
Bye, thanks a lot.
Be safe.